Good evening, everybody. Great to be here, and thanks for giving me a chance to speak to all my fellow panelists. My company's called Stressless in its various incantations. That isn't the word I mean. Incarnations. But I work also for a company called Nexa Law, and that's how I provide my legal services generally. So but I'm going to talk to you this evening about inheritance tax. Why isn't I've been a private client lawyer, which is property, which is trusts and wills and probate, and a property lawyer for over 30 years, but I'm also a property investor, and that gives me quite a unique view as to how things work, particularly of the creative strategies. I know from my days before a property investor, I would have done you can't do that to property investors, and I hear people say that the lawyer won't let me do it, and so I do understand. And in fact, the person who we use to sign our personal guarantees said to me a little while ago, you shouldn't be doing any more than this, you know, because you won't be able to sleep at night. And I thought, oh yeah, okay, this was only about number 2 or 3, you know, so but he seems to have stopped now. But yeah, general lawyers looking at things like that. So I'm going to talk to you today about inheritance tax and a beginner's guide, because there's lots of myths about inheritance tax, and people don't understand how it works. And there are also some really stupid things. And I'll come to one of those in particular. I find it very difficult, and it's very hard to explain to people. And I'll be talking about that a bit further down. I want to dispel some myths about grants probate and letters of administration. Grants probate is if you have a will and you have a certain amount of money, so usually over 15,000, you will have to get a grant of probate, and it will take a long time. At the moment, I've got one which is not happening, shall we say. The person has been dead 14 months now, and there's something slightly wrong with the will, and the probate registry won't issue it. So we've got £2 million houses sitting in London that we can't get rid of because we can't get a grant of probate. Letters of administration, and this is where things often get mixed up. Letters of administration are if you don't have a will. So your authority as an executor is taken from the will, and you can start acting as soon as you can, soon as you sort of soon after death as possible. But let them get cold. I really don't like people who come to me the day after someone's died and say, I want my money, and I, believe you me, have had them. Letters of administration, you can't do anything until you get that. And there is the peculiar thing of both, which is called a letters of administration with will annexed. So if there's something wrong with a will, you can often have a hybrid of the two. And I have one at the moment where both executors died. It's a very old will. And so we have to use the will that we've got, but we have to use separate executors. So remember, if you have a will, it doesn't mean you don't need a grant of probate. And that was one of the things I really wanted to point out here, and the difference between probate and letters of administration. Inheritance tax. Roy Jenkins was the person who introduced inheritance tax, the abolition of death duties, and I think this is one of my favourite quotes. You know, inheritance tax is a voluntary levy paid by those who distrust their heirs more than they dislike the inland revenue. And you'll be surprised how many people that takes in. There are considerable amounts of people. Inheritance tax is avoided in life, not in death, and that's what Roy Jenkins means by that. You can't, it's no good coming to me. I had somebody a few months ago consult me, and they wanted to reduce their inheritance tax burden, which was over £1 million. And I mean, the payment was going to be over £1 million. The estate was very large. I think off the top of my head, it was going to be 1.4 million. And they came to me to discuss this, and it was their mum. And she was well into her 80s. Now, if you give anything away, you've got to live 7 years. So you can't, and sometimes you can't afford to give it away. So there'd have to be other mechanisms, and you have to look at how other things work. You know, if you need the income, you can't give it away, because you can't give something away and keep it. That's called a gift with reservation, and you'll still be entitled to full tax on it. So you have to be giving away things that you can't afford, that you don't need. You can't give away things you do need, which causes problems as well. So that gives us the estate planning, which is what happens when you're looking at inheritance tax, and it's the arrangements to ensure that everything is in place, so that you've got all your documents that will help you move forward. And if any of you heard me do the talk I did last time, I talked about all those documents. And you must start with stage 1, with death planning. You must plan what's going to happen when you die, because nobody gets out of it alive. And actually, we don't know when it's going to happen. And because we don't know when it's going to happen, it's no good planning for life. Start by death and then move on to inheritance tax planning and your lifetime planning. And that can take a number of forms. And we'll talk about some of those later. I want to talk about nil rate bands. They're something that's very not understood very well. I want you to note that they're a nil rate band. They are not tax-free, they are nil rated. We all know that the Chancellor is trying to raise more funds. We also, I will give you the example that power charges were nil rated until some time ago. Can't remember when. And they introduced VAT. They were nil rated VAT, and they introduced VAT onto power charges. We were only supposed to have luxury goods on VAT. VAT was only supposed to be payable on luxury goods. Electric isn't luxury. So the nil rate band, everyone has one nil rate band, 325,000. And they get that free. The last increase on that nil rate band was April 2009. And it's now frozen till 2026. That was announced in last year's budget. There is a second nil rate band, a residential nil rate band. Now that's available to a limited amount of people. You can only use it if you live in the property and if you leave it to direct descendants. So direct descendants, there's a nice list in the Act, and very helpfully, the Chancellor or whoever drafted it included stepchildren in that direct descendants list. So even if you haven't got any children of your own, if you're married to somebody who has, you get that extra help, and that's 175,000. So in that limited situation, you will get that. So that gives you 500,000 in the nil rate band. That's frozen till 2026. When it started, they phased it in over a number of years. It started at 75,000, and over the next 4 years, it went up by 25,000. and they were supposed to increase that by a rate of inflation, and it's index linked to an index, and it was going to raise. And this time last year it was supposed to have its first raise, and it was very quiet, and it took me a long time to find it, and I found it buried in the bottom of the budget speech to say that it wasn't going up, it was going to be frozen. So it too is frozen till 2026. The other thing is that you don't get the residential nil rate band if your estate is worth, or the full one, if your estate is worth over £2 million. It starts to drop away at a taper of £1 for every 2 over the 2 million you have. So when you get to, it's about 2.4 in round figures. If your portfolio is worth more than that, then you won't get anything. So you're back down to the 325. So keep that in mind. So one of the things that's really important is the fact that they're transferable. So this was that when I was first a lawyer, they couldn't be transferable. We used to do all sorts of strange mechanisms, and you may have parents maybe who use these mechanisms to make sure that nil rate band was used, because otherwise it was lost. So you would leave half a house, and then a mortgage would be given back to the surviving partner by the estate, and then the mortgage would stay in the trust, so that the nil rate band had been used. But I suppose we all got expert at doing that and avoiding it. And actually, it was about 2006, 2007. It was agreed that nil rate bands could be transferred as long as you're married. You can't transfer them otherwise. So if you're not married and you are together, on the first death, there will be an inheritance tax bill to pay if the sums add up. And that can be really difficult. I spent my career telling people they should be married. And they just used to laugh. And in the last 3 years, I think I've had 4 or 5 couples who've got married for tax purposes, quite literally, because when they did the sums, the survivor of them having to pay that tax bill would have broken them. Certainly, and they're mostly property people. If you're looking at having to sell a large amount of your property and you're expecting to live to pay the bill, then it's a better thing. So should you be married, you can sneak off. I had one couple who eloped to Gretna Green as a laugh and then had a barbecue when they came back. But it really, it's really worth considering. So to work out your liability, you have to add the value of all your properties together. If you've got a limited company, the value of the shares in your limited company, and we'll talk about those a bit further down the line, and I'm sure Shaz will talk about them. He's the expert on that, not me. I just know to send people to him. The value of all the money in your bank accounts, the value of your insurance policies. If you haven't got those sorted out, so insurance policies will fall into your estate unless you have them in trust or you have them nominated to somebody outside your estate. That's really important. If you've got massive death in service benefits, which a lot of people have got, and you're still working, and you've got, then it's a big, you've got a lot of money going in, which is going to be taxable. All death in service benefits can be nominated, and depending on the insurance company, the policy can either be put in trust, so it passes outside your estate, or a beneficiary can be nominated. It's really important to do that, because to get a grant of probate, you need to pay the tax. So you have to pay the tax before you get the grant of probate, before you can collect the assets in. which is the thing I was referring to at the beginning, because that's really unfair. It always seems to me, banks are a bit better than they were now, but you know, when I was a young lass, banks wouldn't let you have the money to pay the inheritance tax. They're a bit better now, and some of them will. And if there's, but there has to be money in the bank. You can't sell a house. So it really does need, you do need to think about that. You also need to add your other valuable assets. So if you've got watches, cars, things that are, they're all taxable. So add all those together. You should do this once a year at least. So add all those together and then take off your mortgage balances. So any mortgages you've got, any other outstanding debts you've got. And that includes like JV agreements, things like that. Don't forget to include them. And your funeral costs can be taken off of that. Now, sometimes that can tip the balance. So remember to consider it. If you've got an elderly parent who is slightly in the balance of not getting help with their care costs, buying them a prepaid funeral plan is a good way to take them underneath that thing. But that's an aside. But, you know, I've seen funeral bills in the last 12 months from about 3,500 to 15. And they're somewhere in the middle there. So you take so you add everything you've got, you minus those three things, and then what's left, you take off your the nil rate bands you're entitled to. Now that could be, if you're married and you are the surviving partner, up to £1 million. It could be 325,000. So depending on what, and everything that's left after that, you will pay 40%. And that has to be paid prior to you getting your grant of probate. So who pays? You pay. The dead person pays. That's the official line. And you have to pay, as I said, before you get the grant of probate. How do you pay? There are varying ways, and sometimes executors have to pay. So the executor is, because they stand in your shoes, they are liable to pay that tax. So if they don't pay it, which is why being an executor is very onerous, they are the ones responsible. And I've had executors who didn't understand and have distributed the whole estate, not got a grant of probate because they didn't need one, it was a lower one, and then found that there were some debts and have been taken to court over those debts. So don't, you know, make sure you know how if you've got a liability, how it's going to be paid. So that's part of your life planning. And some of those things can help with that. You need to make provisions for it. You need to, if you've got JV agreements, you need to include in them what happens. Key person insurance is an insurance, I was talking to Claire about it earlier, and it's a very important insurance because it will help the business run if you're ill. Or would you like to be in business with your business partners nearest and dearest? It might be you, but it also might be somebody else. And if you don't particularly want to be in business with them, you want the money to pay them off, and that money comes into the company. So you don't particularly want to end up with that person as your business partner. We've got the skillful accountant coming next, but you can use limited companies in your lifetime planning. So you need a skillful accountant to do that, because you can change the class of your shares so that you have no capital and growth in your shares, you have income only. And if you're leaving a legacy to your children, you can leave them the capital and growth shares. Therefore, yes, there'll be inheritance tax to pay on the value of your shares, but they'll be worth less. And sometimes it's important just to do a sum and see how you're going to get paid. Gifting. If you have an inheritance tax problem, you are able to give away £3,000 a year. without that being added back into your estate. That isn't a potentially exempt transfer. At the moment, you have a very unique window. It only happens at this time of year. You can give your £3,000 away for the last tax year. You can give your £3,000 away for this tax year, because you can only go back 1 year. And in a few weeks, you'll be able to give your £3,000 away for the next tax year. So if you've got somebody who you need to get rid of a lot of money for, that's a really good time to start giving it away. You can also give away income that you do not need to live on tax-free. So if it's income, it can be given away. You need to speak to your accountant about that. And that then isn't added back into your estate under the 7-year rule. You could use trusts. So you could make gifts into something called a discretionary trust, of which you could be a beneficiary. But you need to make sure you trust your trustees to do what you want them to do. And those trusts can give loans. So you could put money into it and it would help preserve family wealth if the money was in the trust, and you had a child who, and I get this often, that the children, they don't want the children to have anything to, they're worried they're going to get taken for a ride, or their money's going to get taken off of them by an unscrupulous partner or whatever. The loan could be given then from the trust, and the trust would be entitled to interest if necessary, and instead of a mortgage, and therefore, because that the equity would only be subject to matrimonial settlements. So peace of mind documents, your will we talked about, your lasting power of attorney, partnership and shareholder agreement, all of which help you move inheritance tax into the place. I always include an advanced directive living will in this. I think it's really important because there is no substitute for talking. And the fifth thing, is your emergency planning file, and it's a service I'm just starting to launch, and it's something I want to help people with. I'm really passionate about that. But I've heard of property investors who are unable. They're ill and they come to, and their properties are empty. They need remortgaging, all sorts of things. You need somebody to be able to run that business for you. If you die in an accident suddenly, how's the business going to run? And so the plan would be that I would help you formulate this file, and that could include notes on properties that are worth selling to pay your inheritance tax, that they're worth keeping because they're a good cash flow, and you can leave instructions from beyond the grave. It's very difficult, you can't make people do that, but they do need to know, and if you don't talk to them. We've had my elephant all the way through this, and it's turned up in corners because, and I don't mention it, but it is the elephant in the room that nobody talks about. So don't let it be you. Talk about it. No substitute for talking about it. Even if you talk about it to somebody like me, who gives you everything ready so that you can just do it. If you can't talk to your family, then it's really important to talk to somebody. So I'm giving away some emergency planning calls. There's a limited number available. Get a 15-minute call. I'll give you some recommendations. The bit.ly link is there. I'll put that in the chat box later. And if you just want to contact me, I'm best got on my Nexa email. So yeah, come back. Come to speak to me in the breakout room. I'm not sure, Claire, if we've got a few minutes for questions and answers or whether we've got to press on.